and she had no money to put into the house whatsoever. Her husband had not been paying her support, evidently. At the same time, the market was crashing. So this is in 06, 7, 8. The market is crashing, and I'm hearing lawyers who are advising their clients to just let the house go, just let it foreclose.
Hi everybody, Jose Luis Morales here. Welcome back to another episode of the Laurel Starks Show. Today we have a very special guest. The name is Laurel Starks. She is the CEO of Starks Realty Group and Alumni Institute, which is an institute that specializes in helping real estate agents get trained for divorce family law cases. And today we are going to talk about, if you're a real estate agent, how do you target divorces as a realtor in California, or how to get divorce real estate listings just in general. I met Laurel a couple years back. I was looking to get into the niche. I started looking up who did the most business in divorces, and I came across Laurel. I've been through her training. I know that it works. So, welcome to the show, Laurel. How are you?
I'm great. Great to see you again, Jose. And you are indeed one of our OG CDREs. So it's exciting to be here on this side of the mic with you.
I agree. So for our viewers that don't know who you are, who is Laurel Starks, and then how did you get involved in this niche of divorces?
Yeah, sure, absolutely. So as you indicated in your intro, I have two businesses. So my firstborn is Starks Realty Group. So I work in Southern California, specifically in the Inland Empire area, as a court-appointed divorce real estate expert. And then I started the Alumni Institute about a little over 5 years ago. We'll talk about that in a second, but I got started in the divorce space actually very early on in my career. So I had a former career in the airline industry, had nothing to do with real estate, nothing to do with law, and I got my real estate license, and my second listing was actually a divorce real estate listing. I got a call from a family law attorney who had a case that they couldn't agree on who to use as a realtor. So he gave my name to the judge and said, "How about Laurel Starks?" And the judge said, "Do either of you have any issue with that?" And they didn't. And so they said, "Okay, great. You're the listing agent." So just let that be your lesson number one. That is how much consideration the courts and the attorneys gave to the listing agent. It was my second listing ever. Okay. So that's how much they cared about vetting the real estate person. So then I got a call from who would soon be my client. And she said, "I need to sell my house. I've got to move my son up to Oregon. He needs to start school in 30 days. And so I need to get this thing on the market immediately. Can you come over and sign now?" So I went over to her house, and the house was in a lot of disarray. There had been a lot of deferred maintenance, and she had no money to put into the house whatsoever. Her husband had not been paying her support, evidently. This is what she sat down and for 3 hours spilled all the beans about the demise of their marriage. And she had no money and needed to get it, done right away. She said, "I doubt that my soon-to-be ex, is going to be cooperative. So good luck trying to get a hold of him." But so I did reach out to him, got his information from his attorney, and sure enough, I mean, he took my call the first time when he didn't recognize the phone number, and he said, "Yeah, pound sand. Hell will freeze over before I ever sign anything and cooperate with you or ever talk to you again, because my wife wants to take my son out of state, and as soon as the house sells, that's what she plans to do, and I plan on dragging this whole thing out so that she can't." So That is lesson number 2 and 3. So lesson number 2 is that you go into these houses, and a lot of times there's been deferred maintenance. I mean, you don't typically walk into a divorce listing and they've just gotten done planting the begonias and touching up all the baseboards and doing all of these things. The
Yeah.
the house is not the most important thing in their life. So lesson number 3 is that there is something much bigger going on, and the house and the listing, if you will, is being held hostage. It's kind of being used as a pawn. So there's no sense of urgency I can use, right? There's no sense of like, well, but if you list it, if you wait a month, then the market might change, and all of these sense of urgency type things that we've learned as realtors, completely irrelevant in a situation like
Mm-hmm.
this. So he was true to his word, and he actually never did talk to me again. So how do you list and sell a house when you have no contact with one of the owners? My broker didn't know what to do. Mentors, people that were experienced agents, really didn't know what to do. They're like, well, try this and try that. And it was just very confusing. So I found myself in court a couple weeks later. The attorney for the wife who got me on the case said, well, I need you to come and tell the judge what all you've done to try to get the house sold and all the attempts you've made to try to reach him. And then you need to tell the court what you need in order to proceed with your job. So I'm sitting there on a witness stand, and had never stepped foot in a courthouse, and telling the judge what I did and what I need. And so the judge was very interesting. The judge kind of almost, what I would say, pushed the eject button on him and said, fine, we don't need him to effectuate the sale of the property. I'm going to appoint someone to sign on his behalf. So, I didn't ever have to talk to him again. I just had somebody sign on his behalf. So that was all a very interesting, thing. We did get it sold. She got up there, and the son Jacob started school within 30 days. My second listing, and I'm not going to go on and on about every listing in my career, but my second listing, it was a case where the wife lived in the property with her 5-year-old daughter, and there had been significant domestic violence, and she was very afraid for her safety, her daughter's safety. Didn't want an open house, didn't want showings, didn't want a lockbox. So how do you navigate that, right? How do you sell a house when, the occupant doesn't want access? So I learned after a handful of these that this is really something that is not taught to realtors. I've got to figure out this skill set. At the same time, the market was crashing. So this is in, 06, 7, 8. The market is crashing, and I'm hearing lawyers who are advising their clients to just let the house go, just let it foreclose. They were not aware of loan mods. They weren't aware of short sales. They weren't even up to speed on the deficiency protections, deficiency laws, if you will, and let alone what it does to credit if you let a house foreclose. So I became an educator to lawyers at that time. I realized as I'm learning this stuff, they need to know it. They're the first line of defense when it comes to navigating what to do with the house in a divorce case. So figured they needed to learn from me what the options were and what the ramifications were. So I became an educator. And then, over time I learned and stumbled and failed, and and what is it they say, fail your way to success. So
Mm-hmm.
so that's what I did. Today at Starks Realty Group, I only take listings under court appointment. I don't work in traditional environments. And so I then bottled up my knowledge, because I felt like I could see the difference I was able to make in the lives of families, in the lives of lawyers. And I saw the benefit of having an expert for the court. So I felt that this knowledge is something that needs to be shared. So I basically deconstructed my whole process of how did I build this business, how do I handle this business, and I created something called the Alumni Institute, which is the certification organization for certified divorce real estate experts, CDREs. And it's a rather rigorous training program. As you know, Jose, you have to apply to get in. You have to, have several interviews, and then the program itself is rigorous. So, but it's important because this is an important um, segment of real estate. It's very complex, and you've got a family's future riding on it. So you got to know what you're doing. So that's a little in a nutshell.
What I would say is the reason I wanted to do this video, Laurel, with you is that I believe that the best way to get divorce listings is to understand the process and get educated on how everything works in the background. Let me give you guys an example. Like I get a call from a divorce lady who says, I want you to come list my property like tomorrow. I'm like, great. How long in the process are you? She's like, I just filed yesterday. Then I say, okay, great. Does your significant other want to sell the property, or the ex or your ex-husband, does he want to sell the property? She's like, nope. I'm like, it doesn't make sense for us to meet because if he doesn't want to sell, we're going to need him because both parties were on title. So the purpose of this video is we're going to talk about all the different challenges that realtors and judges face and attorneys face, just so that you guys get an idea of everything that could happen in a divorce listing. And at the end of the video, if you like what you see and you want to get certified, Laurel can actually, you can reach out to Laurel and her company and potentially apply to be a alumni, part of the Alumni Institute as well too. So let's start off here. Who selects the real estate agent in a divorce case?
Good question. So, there is no uniform process. So sometimes it could be the parties themselves. They decide that they mutually want to hire the friend or the person that sold them the house or something like that. Other times it can be the lawyer who will make the recommendation, and then the parties agree. I think what's really most important for realtors to understand is that there isn't one person who makes this decision. This decision has to be made by either mutually agreed to by the parties, um, or the court will sometimes make that. Usually, that's another kind of a myth, I would say, that judges make these decisions. Ordinarily, what happens, and this is national, this is nationwide, because I teach and train agents in over 40 states. Um, Typical, what the customs typically are is, if two people, if they can't agree and they're in court, the judge will make an order and say, well, you spouse A, whatever you call them, the petitioner is to give three names to the respondent, and then the respondent gets to pick from those three names. So that way, everybody's had a little bit of, it's been a little fair, if you will. But that's usually as deep as the judges will go. Judges typically don't like to make the decision on who the realtor is, for a whole host of reasons. But once in a while, they will, if the conflict just keeps going.
Got it. Okay, so it could be both parties agreeing to select a real estate agent, or it could be the attorneys putting the names of three agents in a pot, or it could be the judge. So there's a variety of different ways for it to be handled in that case. What happens if only one party wants to sell and the other party doesn't want to sell?
Yeah, that's what courts are for, right? So a lot of times if one party wants to sell and the other party doesn't want to sell, I mean, they will ultimately, if they can't come to a decision, they will take that to the court. And then the court will make a decision. So sometimes before it has to get to a judge, sometimes they will maybe write up an agreement, like a stipulated agreement or something, where it says, all right, the party that wants to keep the house, that doesn't want to sell, has 90 days, for example, to buy out the other spouse. If they can't, then it's to be listed for sale. So sometimes it's that. Other times, they've got to go into the court, and they both argue their case, and then the court might make an order that's kind of similar to that. Usually,
What happens if only one person is on title and that person wants to sell the property, and the person that's not on title doesn't want to sell the property, but they've already started the divorce process?
yeah, this is where things get really sticky between the uh, family law and real estate. So and I'll speak to California. Um, so in California, and by the way, I'm not a lawyer, so this is not to be construed as legal advice. Um, but we all know that in California, we're a community property state. And so it can be common that two people have a house, and they both have an interest in that house, even if one party is only on title. I mean, Jose, you've been around long enough in real estate. We know it's not uncommon at all to have one spouse on title because maybe their credit was better. Maybe if they're the breadwinner and their credit's better. There could be a whole host of reasons why only one spouse is on title. Maybe they've got more of a the one spouse has more of a debt load. Maybe they're investors and they want to kind of share in the debt load, et cetera. There could be a lot of reasons why, but nevertheless, two people can be married and only one is on title and one is on the loan. And what most attorneys would tell you is that doesn't necessarily dictate that is separate property. It doesn't necessarily say that, well, just because it's in your name doesn't mean that it's not community property or that the other spouse doesn't have an interest in the property. So when we as realtors sell a house, we only look at who the titled owner is. That's the only person that exists in a transaction to us. We take the listing, escrow, title. The only person that will exist in a transaction in California is who's on title. The fact that somebody else may have an interest in the property, a community interest in the property, that means that they might be entitled to some of the proceeds, but not necessarily entitled to all the decisions that lead up to the proceeds. And somebody might be like, well, doesn't really matter, does it? I mean, if they're still entitled to the proceeds, they still get half or whatever. Well, what if you've got a titled owner who wants to keep the property, but they have been forced to somehow sell it, and they're the only ones that sign a listing agreement, and they sign a listing agreement, that they sell it for 50 cents on the dollar to their brother. And because they want to stay in it, they know that they can sell it to their brother for 50 cents on the dollar and their brother's going to let them stay there. Well, what did that just do to the proceeds of that the non-titled spouse was entitled to? I mean, we could be here all day with scenarios about how those things can get very, very sticky and a lot of nefarious dealings can take place. So it is important that really family law attorneys and courts are aware that when a property is ordered sold with one titled spouse, that they've done something to ensure that the non-titled spouse does have equal rights to making decisions.
Got it. Now, where I was referring more or less to, do the assets get frozen when somebody goes through a divorce or files for a divorce? Like, meaning, like, if we're going through the divorce process and I'm the only person on title, could I sell that property if I'm going through the divorce, or does that automatically freeze some of the assets, like the house?
Mm. Yeah. So, I think it depends on what you define by freeze the assets. So there are things like um, automatic temporary restraining orders. ATROs is what they call them. And if you read ATROs, it can basically be a violation of the I don't know if you call it the court order, but it could be there are like these temporary restraining orders, not domestic violence. I'm not talking. I think a lot of times we think about restraining orders as being violent, but restraining orders with regards to liquidating any assets. So there are usually in California there are things called ATROs, but it doesn't necessarily freeze it. In other words, there's not necessarily a flag that comes up in the life of a real estate transaction that says this is frozen, unless one of the parties files a lis pendens. If there's a lis pendens, that's the big notification, right? That there is that there's some sort of litigation involved. So, but I can't tell you how many times lawyers don't file lis pendens. It is a fraction of, not even 10% of the time do I see lis pendens being filed when there's one titled spouse. Maybe I see it once a year. And so without that, there's really nothing to alert us and to actually stop someone, but they may be in violation of those ATROs and they could get in big trouble. Because once they liquidate that asset, then the other spouse could bring, claims or whatever, sanctions and whatnot. They would work with their attorney on that.
Yeah. Are sometimes divorcing parties skeptical of real estate agents that are friends of one spouse versus another? Or are they typically like, oh, great, let's work with our friend that's a realtor? How does that process typically work? And also, is it typically the in spouse, the person living in the house, that selects the agent? Or is it the out spouse? Or do you see any patterns there?
So I'll take your first question about bias. So what I would say is that there can be definitely there can be bias, a perception, if you will, of bias that comes up. I mean, I'm a football fan. I like Florida State football. We
Mm-hmm.
just played Clemson, and I didn't like the refs. I thought the refs made bad calls. Well, if I had found out that it was Clemson that those refs were like Clemson alums, and they maybe had, they hang out with the Clemson football team and the Clemson coaching staff, and now they're going to go referee a football game. I mean, how does that look, right? You're wondering how neutral, how unbiased are they? Can they be? So I think that's one way to look at it from the standpoint of having certain relationship with only one spouse. Now, there may be a time when, like I said, the house isn't the biggest thing going on in the case, right? They may be dealing with some other very, very serious issues, maybe some custody issues, maybe some substance abuse issues. I mean, there could be all kinds of stuff that's also going on. And one of the spouses might be like, "Yeah, okay, I don't care. Just have your friend Billy list it," and they just didn't give it much thought. And then, lo and behold, they're sailing on with the sale of the house, and Billy never calls the wife. Billy The next thing the wife knows, Billy's, sends her an offer that Joe just signed. And she's like, I didn't even know this thing was on the market. So sometimes they don't even realize because they just haven't thought through how bias can really take over. And when an agent does not have neutrality, or even more importantly, the perception of neutrality, then an agent loses control. They lose trust. And when you've lost trust, you can't get anything done. Forget it. You're kind of dead in the water. So and then it has to fall back on the lawyer's plate, and it has to fall back on the court's plate to start making these orders, and then you've just caused more problems than you have brought solutions and help to a case. It's not good for your reputation. You had a second question, and now I'm
Let me
drawing a
dig a
blank.
little bit deeper on that one. But what's the best way to gain neutrality or remain neutral in a divorce real estate transaction?
Really good question. First,
And
understand that
how important is it to be neutral? That's what. Yeah.
neutrality is everything. So without it, you're done. In terms of how to be neutral, that is that's an acquired art, and that is something that you will spend your career in practice of, practicing, learning, doing. And it's like saying, how do you be a good football player? Well, you can't just sum it up. I mean, you got to put in the time to do it. But I can give some, some practical tips for someone who's just starting out. So first and foremost is communication. So you want to make sure that you control the communication. You communicate equally with both. We communicate separately, which can be something that is a little bit, head scratching. How can you communicate equally if you're communicating separately, right? But we actually have to separate the communications so that we can establish a trusting relationship with each individual. And when I say communicate equally, I mean, you never want the one spouse to find out something from the other spouse or from the other lawyer, versus finding out from you. So, once you talk to one, you need to talk to the other one pretty quickly before you get too far down the road with the other side. And you want to make sure that you stay really in the middle of the communications. In other words, you don't want to you can fall into a trap if you are trying to get them to agree with each other. So you're like, well, how do you ever get anything done if they don't agree with each other? Because you want them to agree with you. So if wife wants to accept an offer, and that, well, if she accepts that offer, obviously we're going to get this thing closed and done faster. Husband doesn't want to accept the offer, and you're really pushing to try to get something done that it may appear as though you're really advocating on her behalf, especially if you say things like, well, she's got a deposit down on a new home. Like, we've got to get this thing in escrow because she's already put down a deposit. And if we don't get this thing in escrow, then she's going to lose out on her deposit. You've completely aligned with her. And he's going, what about my best interest? What about the fact that I want another $20,000 because I think the house is worth another $20,000 or whatever it is. So you've got to make sure that you're not there advocating for either one of them.
And that's even like, so for example, like if I get called by one of the parties and I go over there and do a listing presentation to one of the parties or even give them a value, that could be perceived as almost like I'm like the wife's friend or the husband's friend, and that could affect my chances of getting the listing as well too, right?
Absolutely. They're suspicious of everybody. They're suspicious of
Mhm.
everybody in this thing. They're suspicious of the judge. They're suspicious of their own lawyers. They're suspicious of all the players in this whole dance. And so people are looking at you very closely. And so that's another reason why if you happen to be in a situation where you're together with them physically, um body language, micro communication has to be so on point. Um, and it can be that, you know what, you kind of like somebody better. Maybe, we've all heard how charming narcissists are, right? So it might be that, gosh, we just get along. Like, he's so much easier to talk to. He totally gets it. He's totally motivated to sell the house. She's just, every time I call her, she just bites my head off. And so, I'm aligning with him because he's aligned with me, and she's getting in the way of me getting a paycheck. So she's now become my enemy. So now he and I are ganged up against her. And, that kind of that kind of behavior will land you exactly zero more referrals from a lawyer.
Even so, for example, like when I deal with parties and like I know they're going through a divorce, I may say something like, just so you know, I'm a neutral third party agent.
Yep.
I don't have any sort of relationship with your significant other. I've never talked to him. I have never met with him in person. I've never done absolutely anything with him. The benefit of using me as the real estate agent for the case is that I'm going to remain neutral, and my sole focus is going to be to help the family or help the case get top dollar for the property.
Right.
However, if I have a relationship with one of the spouses, or I've already met with one of the spouses, or I have affinity towards one of the spouses, that may be perceived as not coming off as neutral, and that can hurt your chances of not getting the 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 divorce listing. What I wanted to ask you is, what about listing appointments? So for listing appointments, like, do all listing appointments happen with one spouse first, another spouse second, with both parties at the same time? How are listing appointments different in a divorce case versus just your traditional happy marriage, happy family case?
Yeah. Well, first of all, Jose, exactly what you said is so important, to just address the elephant in the room. I mean, just face it head on and let them know I am a neutral third party. I have no vested interest in either side. My job here is to ensure that you're both treated and represented fairly, equally, and that I procure the highest possible value and maximize your equity. That's my job. So address that head on. Um, and so that, by the way, is a script in my listing appointment. So really the initial steps of it, you're going to get contacted by one side somehow, some way. You're either going to get a phone call from the homeowner directly, or you're going to get an email from an attorney, or, however, it's going to come into you from one side. So the first thing you do is what we call an intake, and you need to ask very pertinent questions. You need to know immediately. You need to know, is there a court order? And if there is a court order, you need a copy of that. You're here to list and sell property that is under the jurisdiction of a court, and there are terms that are in that court order that affect your duty. So you need a copy of that court order. Don't be afraid to ask for that. In fact, if you don't ask for that, then it could be disastrous. So you need to know things like, who lives in the property. You need to know, is there a restraining order? these are all things that you need to know from the get-go. Then you should pull title early. Like the next step is, in my office, we start building a file as soon as we hang up the phone from that initial intake, and pull title. In divorce cases, it's not uncommon to see that there are title issues, right? So there's been a breakdown in finances sometimes. Sometimes, sometimes the house is in foreclosure. Sometimes there are IRS liens. So you definitely want to pull title, and you want to confirm who the owners are. That's another thing. You can even have an in-law in. Like, it might have been like husband, wife, and husband's mom, because she co-signed. So you need to, like, let's establish our our essentials first. Then you want to do an intake with the other spouse. And be careful not to say things like, oh, so I talked to Mr. Smith yesterday, and Mr. Smith did inform me that that you have two mortgages, and that the balance is this and that and the other. And, you don't want to do that. You want to give this person their equal time and just say, hi, my name is Laurel Starks. I was, giving your name, whatever, whatever. Do you have a few moments? Because I would like to get acquainted, and to ask you a few questions. And then you just ask them the questions almost as though you had not even had the conversation with the other spouse. Um, and it'll be
Because
interesting to
that
see.
might, they may think that you're not neutral if you don't do that. They may think like, oh, they're leaning more towards the other party because they're having more in-depth conversations with the other party.
Exactly. Exactly. And it's like, why would you take their word for it? I mean, it's like, no, there's, no, mortgage payments haven't been made in 6 months. Mortgage payments are not current. Why do you believe that they are just because this person told you? Are you going to believe everything they tell you? Um, the other thing you don't want to do is say, because I've done this. So I understand that there are two mortgages on the property. One, the balance is 412, and the other one has a balance of 198,000. Is that correct? No, there's only one mortgage on the property. I didn't know anything about two mortgages on the property. What do you mean there's another mortgage on the property? So there could be stuff that has gone on that the other party didn't know about, and that is not the best way to start out the conversation. Is, exposing that. So in any case, then the next step, once you've done the intakes, the next step is to do a walkthrough, and that walkthrough is done with with whoever lives in the house. So I don't need both parties there. Don't want both parties there. It can actually get violent. I've had situations where there has been violence. So I really prefer whoever lives there. That's it. And I just do a walkthrough, and I'm just there for maybe 20, 30 minutes to just get a lay of the land, see the house. I'm not there to sell myself. I'm not there to, I mean, I'm assuming I have the listing. I'm not there to shove a listing agreement in front of their face. Because again, it's, this is a dance you got to do. And so I'm there to assess the property so that I can do a proper valuation. Once I'm done with the walkthrough, then my next appointment is with the outspouse. So remember, we're toggling communications so to keep it even. Because if I have a listing appointment with the same person I did the walkthrough with, then that other spouse can start to feel like you've met them. They got to show you the house. They told you everything about it. And you've already told them all about, and they've already agreed to the list price. I mean, they start to feel alienated. So walkthrough, and then listing appointment with the other spouse. And I address it, Jose, head on. That's one of the very first things I say is I'm here as a neutral, to ensure, basically what I just said a few moments ago. And then we go from there.
Do you ever ask if they're okay with meeting together or if they have any preference there? Like
Mm-mm.
it's always like, hey, look, I'm going to meet with other out spouse. So if that's the case, what is the difference for the term in spouse and out spouse? And
Yeah.
is that like a
Mm.
term that attorneys use, or is that a term that real estate agents use, or what's that difference?
In spouse meaning the party that lives in the house, out spouse meaning the party that doesn't live in the house. And if it's a rental property or if it's a vacant property, then we don't have an in spouse. Um, and so, but the, can you repeat the question that you asked me just before that?
What's the difference? I asked what the difference was between the in spouse and an out spouse. If that was a legal term or more like a realtor
And
term.
before that, there was something else you said that was a good point.
No, but I was going to ask you after that. Is I'm already on to the next question. The next question was going to be,
Go ahead.
what happens if they have different prices in mind? Basically, like what happens if let's say you're not appointed by the court as an expert, and each party wants to list it at a different price.
Yeah, that is going to be a back and forth. So realistically, part of the other reason why you want to have individual communications, um, and I know you asked me about should you ask them if they want to have joint communication or if they want to meet together. I don't. And I don't make a big deal out of this. This isn't something that we're like, okay, FYI, don't. We do not meet together. We have to meet separately. I don't. I mean, I just go along my process. I just, you know, I just I just have my yellow brick road and it just goes. So I don't I don't make any issue of it. But but the reason why I don't and I don't really give them that option is because we don't know the landmines that are ahead. There, I met with a couple years ago, and they really insisted that they meet together. And I did meet together with them, and I actually made a reference about there was in the front yard there had been some yard work done, but there was a blue tarp over it. So I just made a reference and I said, by the way, this blue, I said, what's going on over here? Can we get this? We'll want to make sure that we get this figured out prior to pictures. And the wife had a complete meltdown, started crying and then screaming and saying that she was working on planting some flowers in the front yard. And that is when she found out that he had an affair. And she abandoned the project, just abandoned the whole thing. And she can't even look at it again because that was what she was doing the moment she found out he was having an affair. I mean, I didn't see that coming, from a mile away. And then he starts yelling at her. And I'm now in the middle of this, and I've got to get this thing back on track. And so there are landmines filled everywhere that you and I don't see.
You're almost like tippy toeing through everything.
Yeah, literally. So, so there's just, you get joint texts going, joint emails going, and then you're just trying to coordinate a showing. And now it's turned into World War III over, well, if you were any kind of a father, you would take Billy to baseball so that, I wouldn't have to and I could show the house or whatever. And it just turns into this whole thing. Well, you've been a stay-at-home mom. You haven't brought anything to the table. And then you're just trying to schedule a showing. And it's in World War III. So let's keep them separate. Let's keep the dialogue under control. And so it's also important that you have transparency because they may not want the other spouse to know where they're going and what they're doing. But you and I need to know that, don't we, Jose? We need to know, well, if you're going to be purchasing something and you're trying to time a closing, I need to know when it comes to negotiating with a buyer. Like you need a 30-day escrow and a 15-day rent back. or whatever.
Mm-hmm.
We need to know some of these things. And sometimes one of the spouses who lives in the house, or maybe the only spouse that lives in the house, they move out. Well, they would not have told me that they were going to move out if we were in a joint meeting. But
Mm-hmm.
since we're separate, they're telling me they're going to be moving out in 2 weeks. Well, now I'm able to say, okay, well, if you're going to be moving out in 2 weeks, we don't want to put the house on the market and then have showings while you got moving vans. So it's important to have that, where they can trust you, and you're not going to go tell the other spouse what their plans are, because it's not really incident to the sale. So that's the reason why, another reason why we keep it that way. If they don't agree on the price, so this is really where there's an art and science to it. If you've built enough trust with both of the parties and they really buy into the fact that you don't have a dog in this fight, you are not there to put his best interests above hers, or vice versa, um, then really it's almost like you have a listing appointment with with um with two separate people, where you've established that trust and you've established that authority and you've established your confidence. And then you're like, look, based on, here are the comps, here's your house, here's this, that, and the other. Just what we do as listing agents, and say, my recommendation is we go ahead and list it for $850 and see what they say. And then if they say, maybe they say okay, and then you go to the other one, and then you have the same conversation, and you say, based on my experience, based on the comps, based on your house, based on the market, this, that, and the other, my recommendation is that we list it for $850. What I didn't do is say, well, you know what? Yesterday I met with her and she wants to list it for $850. Are you okay with listing it for $850? It's not about him agreeing with her. It's about you being the expert and they agree with you. And then if he says, let's say he says, no, I want to list it for $900. You're like, well, $900 is too much. I mean, it's not worth it. I can't support it. You do what we would do in a regular listing, right? You have all of those price objections that we as realtors know how to overcome. Push come to shove, he says, I'm digging in my heels. I'm not listing it for a penny under 900. Maybe I'll say, you know what? All right, how about if we meet in the middle, you and me? Not you and her, but you and me. We meet in the middle. I say 850, you say 9. How about if we list it for 875? And let's list it for 2 weeks. Let's see what the traffic is. And if it's not good, then we'll drop the price. And then he says, okay. Now I run over to her and I say, you know what? I've looked at this and I think we should list it for $875. I'm okay with that. Let's do $875. And let's, drop the price in 2 weeks if we haven't gotten an acceptable offer. Are you okay with that? So it's almost like, you sort of take ownership of that. Because again, if I go back to her and I say, well, he says 900, she's going to say, he's been controlling me my whole entire life. I'm not letting him get away with it again. And it turns into that problem. So those are some of the ways that we're able to address it. It's so incredibly important to establish that neutrality and to establish that trust and the appearance of neutrality. You and I can go, well, we're neutral all day long, but it's how do they see you?
Yeah. What I was going to ask you is, so what is the difference between getting appointed by attorneys, meaning like the attorneys have selected you as their agent, and being court appointed as an expert?
Mm-hmm. Good question. So there can be two different ways. I guess there might be three different ways. So one is, it might just say the property is ordered sold with a mutually agreeable agent. And so then your name's not even in it. They just have to go agree to an agent. That is the least desirable, because they can still say, well, I don't like you, I don't agree with you, and really there's not They just have to keep going back to the drawing board to find another agent. They keep interviewing, and they become these like serial agent interviewers. Um, the second thing is if your name's in it and it says, the property on 123 Main Street is ordered to be, this court orders the property to be listed for sale with Jose Morales. Then that means that the court has ordered the parties to list it with you. It is their order. They have to comply with that. It is the order is that they must list it with you, which is great. It's much better than the first alternative. But it doesn't give you really a duty to the court. You don't really have a duty that's anything different than what your duties are as a realtor. Your NAR code of ethics, your contractual duties, your fiduciary duties. I mean, all of that certainly, but it doesn't give you any other duties. When the court appoints you and it says Jose Morales is hereby appointed as the court's expert under, evidence code 730, or maybe they don't even list an evidence code. They say they appoint you as the court's expert to list and sell the property. You have a duty to the court. You're the court's expert. So you may have to testify. The court is saying, I want there to be a neutral. I want someone who can come in and make recommendations to me, to the court. I want someone who can come in and testify, because we're really the number one witness to this whole thing. So there's that. I guess there's a fourth thing, and that is how much it actually defines. So when the court appoints you, they can actually define what your role is and isn't. It can say, it might go on to say, the court hereby appoints Jose Morales of EXP Real Estate, and Jose is to if the parties cannot mutually agree on a list price, Jose Morales is to determine what the list price is. So that it might give you a power, right? And so in a case like that, it really outlines what your scope is. I have a stipulation, and my stipulation is about 4 or 5 pages long, that outlines my whole entire scope of what my role and my job is, as the court appointed listing agent, and what it isn't. Because there's a lot that I don't do. So that's some of the differences broken down.
And where I think, and this is kind of what I learned from taking your training, is that there's a disconnect between the law community and the real estate community, especially when it comes to divorce listings, meaning they have their ideas as to how the world works, and then we have our realities of how the world works, and sometimes there's a little bit of a disconnect. So I'll give you guys a couple of examples of where that disconnect is and why it's important to be appointed as an expert on the cases, why that's really the best thing. Are we going to make a big deal if we're not? No. But
Right.
I'll give you an example. Like, let's say that you have a husband and a spouse that listed the property with you, and the court says that they have to list with you, but one of the parties does not want to cooperate with the showings, and they're both on title. As an agent, you have a fiduciary duty to both of the clients. So what do?
Right.
Like,
I mean,
like, are you allowed to go tattletale on that client to the other attorney or to the court and say, hey, look, such and such person's not cooperating with any of the showings?
yeah. I mean, that's where there is such an inherent conflict between our role and what really the court expects, because we do have a fiduciary duty. And so if we have one spouse that says, I don't want a lockbox, and the other spouse says, I want a lockbox. Well, if we don't put a lockbox on, then we're violating what spouse A said. And if we do put a lockbox on, we're violating what spouse B said. So then if you're not appointed and if you're just an agent coming in off the street, then what authority do you have to go tell the attorneys this? What every time an attorney opens up an email from you, their client gets a bill. I'll give you another example where something like this happens quite a bit, where there is a discrepancy in proceeds division. So you've got, where does the money go after the sale of the house? And we as listing agents, we don't care. I mean, what do we care? We don't even get involved in that, where the money goes. I mean, it's just whatever. That's something that the normal people tell escrow where to send the money, and it's usually in a joint bank account or something. So we don't ever get involved in that. Well, in a divorce case, the proceeds are kind of everything, and there can be a big discrepancy as to where the proceeds go. I just had a listing that sold where there was some money that was owed from the husband to the wife for back support. And this figure was in the court order, and it said he owed her $12,000 in back support. Well, he says that figure is old. I have paid that down, and I only owe her like $2,500 now. Well, that is a proceeds, that's a discrepancy in proceeds division. So I sent out an email because I'm appointed. I sent out an email to both attorneys asking for clarification for this. Without being appointed, or at the very least, without having explicit permission from the clients to communicate with their lawyers, I don't have the authority to do something like that. And it can get really hairy when you've got a spouse who is depending on their proceeds to go buy a house, and maybe they've got another house under contract and they need the funds from this one to go, as a down payment. But maybe there's no instruction in the court order about where proceeds go. And so as a listing agent, I reach out to the attorneys and I go, well, what's going to happen to the money? And the attorneys are like, oh, whoa, no, it's all going to go to attorney trust account. We haven't divided it yet. It going to attorney trust account has just blown up the purchase of my client on their purchase. Now they've got damages. They've lost their deposit and whatever else. So what authority did I have to go tell the attorneys this? As a regular listing agent, they're not my clients, the lawyers. They're not part of my transaction. I wasn't ever given permission to do that. So it can be a very, you can be treading a liability line. You got to really know what that is. And we've got to make sure that courts and orders comply with, with our role, because it gets very messy.
I agree with you 100% on that. Let me ask you this: like, what if you're on the court order? Because this happened to me recently, and I was kind of like, oh man, what do I do? And they got mad because I requested a copy of the order. And they're like, how dare he? Like, there's confidential information in that court order. How dare he reach out to our attorneys to get that? They gave it to me regardless, but they were upset already at the very beginning. And then after that, they instructed me not to communicate with their attorneys ever. And I had some issues where we had an offer that was pretty close to the asking price, and one of the parties was digging their heels in terms of the price. Like, what can you do in a situation like that when they've instructed you not to reach out to their attorney, but you're on the court order as the real estate agent, but not as an expert?
Not appointed. Yeah. So So I usually will tell my clients, I'll say, look, I try to keep attorney communication to a minimum. My goal is to keep you is to be able to mitigate and solve and resolve issues without having to have attorney involvement. That's my goal here. Um, and and yet there we may come upon some disagreements. So we could do it one of two ways. Either I, as the neutral who has been named in this court order, I can reach out and notify counsel and copy you on the issue. And and then the attorneys are gonna and then we bring them in. Or you're gonna reach out to your attorney, he's gonna reach out to his attorney, and then your attorney is going to fire over a letter to his attorney, and his attorney is going to fire off another letter to your attorney. And it's going to go back and forth in attorney letters, and might even escalate and might even get into court. And now you've both got to pay for hearings. So if I am able to, as the neutral, if I'm able to provide the factual information to the attorneys, it will usually, when we have a dispute, it will usually be less of a costly matter for you. So that's how I do it. But at the end of the day, if they don't allow you to speak to their attorneys, they don't allow you to speak to their attorneys. The other thing you could do is you could say, all right, I will not. I mean, if you don't have the authority to, you might even say, okay, I won't. But and then hope that there are no issues. Because I would hate for you to just lose a listing because you refuse to agree to that. And then there are no issues to begin with, and there was never a reason to bring the lawyers in. But what you could do is take the listing, agreeing not to speak with not to speak with lawyers. But then, if there does become an issue, you say, "Listen, I know you didn't want me to speak with your attorney, but here's my recommendation: that I do speak with your attorney. I bring this to their attention, so that we can move forward. We can keep this thing moving forward." So they might change their mind, is what I'm saying. At first they're like, I don't need somebody else running up an attorney bill. My attorney bill's high enough, right? So it might be that something changed, and then they're okay
I
with it.
had this on my very first divorce case that I got. I had a situation where the proceeds were very thin, and there was a florple that came up, or a lien that was for attorney fees, and I had no idea what that was. And one of the parties was like, "If I don't walk away with this number, I'm not signing anything," and I didn't know how to handle it. So, what is a florple, and what impact does that have on a real estate transaction?
So a FLARPL stands for Family Law Attorney Real Property Lien. And so family law attorneys can take cases subject to getting paid out of the sale of the house. Or getting paid out of a refi or something. The equity in the house would pay their bill, which is a great thing if you've got somebody who can't afford an attorney, but they need representation. So they will file a lien, and it's a special kind of a lien. It's called a FLARPL, Family Law Attorney Real Property Lien. So they can be common. Some attorneys refuse to do them. Other attorneys they do them all the time. So it all can just depend, but yeah, that's what a FLARPL is in California. That's a California thing.
So basically, if there's a florple, it will likely come out of the proceeds from the person whose attorney fees belong to them. Like usually in a sale where it's two parties, potentially proceeds get split 50-50. It's not uncommon for proceeds to be divided in different ways, especially if one party has 100,000 in attorney fees and the other party has been paying out of pocket, basically. And
Right.
that's what I
So
learned
let's
in that
just
case where
Yeah, I
go.
mean, where let's say there's $300,000 in equity, each party gets 150, and one party has $100,000 attorney lien. So then, let's say it's husband that has the attorney lien, and wife has been just paying her lawyer. And there's each party gets 150,000. Then out of husband's 150, 100 grand goes to his lawyer to pay the lawyer's flarple, and 50 goes to him. So the flarple is usually against the equity of the person's rather the person's share of equity who whose attorney it is, right? It doesn't come off the top. It's not like in that scenario, $100,000, the lien got paid $100,000 and then the remainder was divided 50-50. The lien is against
What
the party whose equity it is.
what happens if one party is purposely damaging the property to try to get the values to come lower to get back at the other party?
Yeah, that happens a lot. That's called waste. And so when they waste an asset, they basically are they're intentionally diminishing the value of an asset. So, and it absolutely happens. And it even can happen. It doesn't even necessarily mean that they're damaging the property. They could be sabotaging all the showings, because we know as realtors, when you've got days on market that rack up, that diminishes the value. You know, listings aren't like fine wine. They don't get better and appreciate over time. They diminish over time. The value diminishes over time. So, so even somebody who's purposely sabotaging showings, access to the property, and doing things to accumulate days on market, can be wasting the asset, because then we start seeing price reductions. So that can definitely be a thing. And sometimes they ask us as the listing agent to come in and testify to something like that.
You may not know 100% on this, but is the process of refinancing in a divorce different? Like, meaning, like, if I'm a mortgage professional and I do refinances all the time, are there benefits for you as an agent or a client working with a lender that specializes in divorces, as it relates to counting certain income, as it relates to order from the judges of how long the child support payments are, etc.? And how does that vary?
Absolutely. Yeah, absolutely. And again, I'm not a mortgage professional. And so I would highly recommend anybody who works in this space that they do team up with a mortgage professional who specializes in divorce. But just one phrase in a court order can obliterate the chances of somebody getting a loan. And it can even be something like, again, I'm just sort of regurgitating what my amazing CDLPs tell me. But if let's say wife lives in the house and husband, let's say the house payment is $3,000, and husband has to pay the wife $4,000 in support. And what husband's doing, the arrangement is that husband just makes the mortgage payment and then pays her the $1,000 difference. So what's happening is wife is receiving $1,000 in income. The problem with something like that is that if wife wants to go and get a loan, it's very likely, and I believe it's, their underwriter rules, where that would not show as income. That would, in other words, $4,000. She needs to show $4,000 in support as income in order to qualify for a loan. But because of the way that they structured it, it doesn't qualify as income. It only the 3,000 that he's making to the mortgage payment only doesn't qualify. So she can only document $1,000 in income. That's one. Another thing is there is something called the 636 rule, where you have to have a track record of 6 months of support payments, documented support payments, um, and then 36 months continuance, meaning when children, let's say you've got a 17-year-old, when they turn 18, they're not going to be paying, they're not, support ends. So there has to be 36 months continuance um, of support. And then, like I said, the 6 months of proven. And again, if that 6 months, maybe they've been divorced for a couple of years, but every month they've that they paid bills in lieu of, or they did something kind of creative. It needs to show the 6 months documented. So those are just some little things, but there are a whole host of very specific underwriting rules that are incident to divorce, as well as tax law incident to divorce, that lenders need to know, and and they need to be very educated on. And so there's something called the CDLP, Certified Divorce Lending Professional, and that's what they do.
Got it. This is the last question I had for you. What about, like, do judges ever order things on court orders that maybe people don't realize the implications of it when it's on the order? So, for example, like, I remember you explaining to us about how sometimes they'll put, like, okay, husband to quit claim the property to wife and then stay on the loan, and then he stays on the loan. What are some of the challenges associated with that? And then I'd like to transition as to what alumni does and how you go about helping educate attorneys, judges, and real estate agents after that.
So one of the things that so remember, when courts make orders, they will enforce the orders that they make, but you can't just go into court and have them enforce an order that they didn't make. So there might, and you can talk to a lawyer about the ability to modify final judgments. But what I know is, and I certainly don't know all the ins and outs of it, but what I know is it can be very difficult. Sometimes it can be impossible after a certain period of time to modify a final judgment. So, for example, there could be a final judgment that says wife is awarded the property, and she must refinance the loan to get the husband off the loan. But there's no time frame indicated in that court order. It could be 3 months, 6 months, a year, 10 years. There's no time frame. And fast forward, she's fallen delinquent on the loan, and husband is remarried and wants to go buy a new house with new wife. And his credit score is 580. And so you can't just go to the credit bureaus and say, well, I shouldn't have suffered these consequences. Your name was on that loan, right? So, and then he might try to force the sale and say, well, I want her to sell it. And she's like, well, the court order says that I can refi it, but it doesn't give a time frame. I've seen that before, and that can be horribly horrible for somebody who's stuck in this mortgage and with hardly any ability to do anything about it. And at the very least, even if they could take her back to court, I mean, it's a long process. They've got to lawyer up. It's, it's a thing. Another thing, like what you were indicating, is they might say wife is awarded the property, and a quit claim, husband is to quit claim off the property by, October 15th. He quit claims off the property, so he doesn't have ownership of that property anymore, but he still is on the loan. And again, there may be nothing he can do. And so he's just relinquished ownership for a property that he is financially liable for. So there can be some pretty nightmare, and I've seen them, some pretty nightmare nightmare scenarios out there, because they just,
So
lawyers, courts, they're not realists. They don't live and breathe real estate every day.
So, in other words, as a real estate agent, you can add massive value to courts. You can add massive value to attorneys by getting educated on all this and then serving as a real estate agent that can educate the law community as to some of the things that could happen and some of the implications on certain orders. So, can you talk to us a little bit about Alumni Institute and what you guys do there, and what does that look like in case somebody wanted to get involved? And just for our viewers to know, we touched the tip of the iceberg. This has been an hour and 14 minutes, and we didn't even cover it all. So there's so many different intricacies as it relates to family law cases and family and divorce real estate listings, that it's really important that you guys get educated on this. So talk to us about that, Laurel.
Yeah. So at the end of the day, at Alumni, our we're about protecting the family and protecting the equity in the home, and ensuring that this family, from the real estate perspective, can move on with the most amount of financial resources, because the house possesses oftentimes the highest amount of liquid assets. And we've just rattled off, for the last hour and 15 minutes, we've rattled off, countless ways for equity and for costs to erode. And it's just riddled with it's riddled with ways to lose money when it's in the wrong hands. So our whole entire mission and purpose is to protect that equity, because when people have to go rebuild their lives after a divorce, most of the time they can't maintain their standard of living. They take such a financial hit in the divorce, and they are, functioning with the same amount of money that came into the household now has to support two homes. So it's we know what this does to children. We know what the impact of that. So the more we're able to protect and advocate for the equity in the home and protect that value as much as we possibly can, mitigating attorney's fees and costs, as well as getting this process moving forward, because it could be a toxic environment that they're in. So that's our whole mission, and we believe that it is a trained neutral, a CDRE, really should be the only types of professionals listing these properties. Real estate does not. Real estate school doesn't teach us about these things, and yet there is a tremendous amount of responsibility that's on our shoulders that we have to make sure that we get right, because we're very consumer focused. So we take in a limited number of applicants every month. We have it's a hybrid training, so it is online. It takes 3 months to become certified. Once you've applied and you've gone through our application process, and if you're admitted, we do only admit about 12% of all applicants. And so then we have a very rigorous training course, as well as final exams. And you're assigned a coach and a mentor to usher you through this. We teach and train on the divorce process itself, bias, neutrality, communication, the divorce listing process. We train on divorce lending, like we talked about. And then how to properly build a business. How do you build a book of business with family law attorneys? When, as realtors, we've got quite a stigma we have to overcome. We don't have a good reputation in the industry. And so a lot of times people think that we're out for just a buck, and they think that we're, in it for the wrong reasons. And so we have to overcome that. And once they understand our value, we become invaluable to them. And so we do good work. We've got a code of ethics that we abide by as well, that is over and above the NAR code of ethics. And then we've got a wonderful, fabulous community of CDREs who are all kind of pioneers in their own communities throughout the country, who are building their businesses. And we just got back from our annual conference in San Diego called Elevate. We have ongoing training. We do monthly case studies. We do monthly masterminds. We also teach and train our students to give the education, like you said, Jose, give the education to the lawyers so that they can walk into a law firm and give a lunch and learn packed with all of this information that lawyers need to know. And they will also, through us, they'll be able to give continuing legal education credit to those attorneys for that. So we've got that as part of our program. And we also host something called Raising the Bar, which is a monthly online continuing legal education series where our CDREs invite their attorneys to, and they're given a guest pass so that they can attend these, with their fee waived. So it's a phenomenal community of change makers and pioneers, who are in it for the right reasons and who are building extraordinary businesses. It's really changed a lot of lives. So it's a pretty rewarding venture for us. But like I said, slowly but surely we're making our way throughout the country, and we're now getting a lot of, we get calls every day from realtors who were referred to us by lawyers, or referred to us by judges, because we are starting to become the gold standard out there.
I love it. Well, Laurel, I want to say thank you so much for taking the time to be on the show. For today's episode, we had Laurel Starks. She talked about how do I target divorces as a realtor in California. We also talked about how to get divorce listings in real estate. If you've enjoyed this episode, make sure to hit that subscribe button. And if you feel that this episode was helpful, make sure to hit that share button. If they want to get in touch with you, is what's the best way for them to do that, just so that they have some sort of a website or somewhere that they can go to if they want to get in contact?
Yeah, the alumniinstitute.com, ILUMNI institute.com.
All right. Thank you so much, Laurel, again to our viewers. Until next time.